Welcome to Whatsoever More or Less. My name is Jason, and today I want to recommend a talk to you. You can find it on the LDS, Church of Jesus Christ of Latter-day Saints.org, I think is what the website is. I just automatically go to the website, but anyhow, the church website. It's called Fundamentals of Our Constitutions by Dallin H. Oaks. And in that talk, it's given in 2010. He gives the most direct analysis of judicial review and where it's appropriate versus where it isn't, if you ask me. I've pointed out before in defending our divine, and I had this talk in my head for years. I just hadn't reviewed it in a while since I've gotten really deeply into reading the Constitution on a daily basis, to where it's just an all-encompassing big picture that just makes sense to me at this point. I highly recommend you try to get there in your lives too. You kind of have to do it every day for, I don't know, 5-6 months, something like that, where you just kind of say, wait, what's the list again here? What's this here? What's the procedure here? And you just review it daily, till it's all in your head, right? And then you have a massive cross-reference in your head. But since then, I remembered about this talk and went and searched the church website, found it, and the one thing that I remember him saying, and I think this is an important point to make, the ultimate accusation that you can throw against someone is that they're doing something unconstitutional. And you really want to reserve that accusation for when you can absolutely point to why it's unconstitutional. And I think that's why in his talk at the University of Virginia about what's that called, going forward with non-discrimination and peace or something like that, anyhow, he refers to the Kim Davis case where she denied a marriage license after the Supreme Court had ruled that same-sex marriage was legal. He refers to that case as someone to throw under the bus because her defense was her First Amendment rights. But when you're acting as a government official, that's literally the weakest defense, and that shows a real lack of ignorance of the Constitution. When you're a government official, your First Amendment rights don't apply. What instead applies is the Ninth Amendment rights of the people over whom you are exercising authority. Okay? And but anyhow, coming back to the point here, and I do recommend that University of Virginia talk where he talks about the courts being ill-suited to the legislative lawmaking process and some of the psychology behind it, the winner take all that kind of stuff. Excellent talk. I also recommend Defending Our Divinely Inspired Constitution, where he talks about that amendments are inspired, but Supreme Court rulings on the meaning of the Constitution aren't. And I recommend Jesus Christ, Gifts and Expectations by Ezra Taft Benson, where he references David O. McKay and says, could it be that the Constitution is what the courts say it is? Surely it cannot be. But the Constitution is what the founders said it was and what the prophets say it is. Because you have to remember, one of our claims is, in our doctrine, is that whether or not the founders knew it or not, when they were writing what they were writing exactly what the Lord wanted them to write. So look up the quote from, who's the best quote on that one? John Taylor, I want to say, has one of the best ones. It's the most concise in declaring that. But even still, David O. McKay and Ezra Taft Benson, I just pointed that out. So it's the fifth gift and expectations in the talk, Jesus Christ, Gifts and Expectations. But coming back to fundamentals of our constitutions, he talks about that our constitutional form of government and the separation of powers anticipates that the judicial branch will do a certain amount of kind of saying what the law is, or sort of legislating almost, right? But that specifically should confine itself to where laws pass through, say, for example, the Article 1, Section 7, Clause 2 process, have a vagueness to them. Use words such as unreasonable, or words like that that are impossible to perfectly quantify, right? And that then judges would quantify that, right? However, he says, so that is anticipated in our form of government. However, when judges begin to meddle in interpreting constitutions themselves, it's a different thing. See, when you interpret laws legislated through both houses and then passed through the typical signature of a governor or a president, right? You can simply undo what the judicial branch did by the legislative branch coming in and then writing a more specific law, a more clear law through that legislative process, right? Okay, we didn't like the way the courts interpreted that. That didn't work out so well. Let's rewrite the law with a little bit tighter language. Done deal. Easy enough. However, the amendment process, which is permanently binding on everybody, at the federal level, Article 6, Clause 3 says everybody's supposed to keep an eye that the constitutional is defended, right? Any government official, period, all of them. But when it comes to interpreting constitutions, that interpretation isn't easily replaced. The Article 5 process is intentionally difficult. And that should be that way. The Constitution is part of our fundamental law of Zion. It's training for Zion. In Zion, they were one heart, one mind, right? It's not a simple majority. It's not 5 out of 9 judges. It's not this or that exercising authority over everybody else. Instead, what it is it's a very substantial, provable amount of people that really want something, right? So that's what should really be done. And for judges to come in and interpret away the Constitution itself, and treat the Constitution as though it's vague, and though that's their prerogative to redefine the vagueness, that's where Dallin H. Oaks says that judicial review or legislating from the bench, judicial tyranny does go wrong. So that's the big point. Anyhow, this is my quick notes on it. Look up the talk itself. It's called Fundamentals of Our Constitutions. It's on the church website, given back in 2010. It's by Dallin H. Oaks, and he's talking about how the Constitution should not be treated this way. And anyhow, that's what I've got for you. Regarding this, I was just watching The Chosen. Let's go ahead and compare the courts defining our Constitution for us to the big complaint that Jesus had against the Pharisees. And I highly recommend, of course, the Easter, the triumphal entry into Jerusalem episode, for today, of course. Palm Sunday, right? Excellent episode. But he says, you're complaining about her taking off the covering of her head. That's your tradition. That's not what the law of Moses actually says. You're treating it like it's the law of Moses, but it's not actually the law of Moses. And so I think that's a great little kind of example of what made the Pharisees so wrong, was they saw their traditions as so important, their interpretations, their additional add-ons, and they liked exercising authority over others. That's part of why Jesus called them hypocrites. They liked exercising authorities, holding the others to this or to that, even though it wasn't actually part of the law of Moses. They liked, having this extra authority. And so we got to be careful about that, I think, too, in the way we run our own government. If a government official who's taken that Article 6, Clause 3 oath likes exercising authority that the courts have granted them that's not actually in the Constitution, and that the Constitution doesn't even allow for laws to be passed through the Article 1, Section 7, Clause 2 process that exercise those authorities, then they might kind of, think about the Pharisees, right? Just saying, just being honest. So, excellent talk, Dallin H. Oaks. I am this much more solid now. This is my final conclusion, you guys. He doesn't like the courts interpreting away the Constitution. He says that should be done with the most seriousness and reverence and absolute quest to prove the truth. And I'm going to point out 2 things that we do that need to go away. If you ask me, they're incredibly dishonest. One of them is the ex parte Young doctrine. That's where you can bypass the 11th Amendment by suing a government official at the state level, because you can't take a case against the state itself according to the 11th Amendment, right? And then the other one is the waiver of sovereign immunity, to have the Supreme Court take on a type of case that wouldn't typically be part of its jurisdiction. Now you might say, okay, the 14th Amendment gives the courts all sorts of jurisdiction. First off, the 14th Amendment doesn't even address the courts, if I remember correctly. I've studied a lot in depth in the past, not lately. And second off, it does grant powers to Congress. But here's the big one, is how was the 14th Amendment ratified, you guys? It's not real. It's not real. Okay? Ratification is the consent of the governed. There is no such thing as forced consent. I just don't know what to say, guys. I'd love to say that the 14th Amendment is legitimate for all of you guys who love it so much. It's not. 13th and 15th aren't either. That's just all there is to it. There's no other way to say it. The Constitution already gave us the rules for what the qualifications are of members of the House of Representatives and the Senate. Okay? It only gave the existing members of the House of Representatives and Senate, the authority to judge those qualifications, not to invent new qualifications. To invent new qualifications would require an Article 5 process first. That's the way the Constitution works. But you guys, you have to study the Constitution daily for probably at least 6 months before it starts turning into this big picture in your head to where you can point it out. It's kind of cool though. Once you're there, think of 2 Nephi 32, angels speak by the power of the Holy Ghost, where they speak the words of Christ. Who's claimed credit for our Constitution that he's established it? Jesus Christ himself. You want to receive revelation from the Holy Ghost about, you want to be that person that Dallin H. Oaks doesn't say, hey, you kind of sound dumb, accusing everybody of doing something unconstitutional, when you can't even sufficiently point to the actual Constitution. You want to feel no longer dumb? Study the Constitution. It's amazing. It's life-changing. I highly recommend it. And I do think it's the fundamental law. Well, I don't think I know, because I have a testimony to all the prophets who said that it's the fundamental law of Zion. And if they said it, then period, I stand by it. Done deal. So, all right, thanks for listening, you guys. Have a great day.